Hello, and welcome to the ATPE podcast, brought to you by the Association of Texas Professional Educators and covering the hottest topics on Texas educators' minds today.
Hello, and welcome to the ATPE podcast. My name is David George, and I serve as editor for ATPE News. In this episode, we continue our three-part series on educator leave. Whether you're planning for personal time off, dealing with illness, or just need to understand your rights and benefits, we're breaking down the different types of leave and how they work in districts across the state. Today, we're focusing on protected leave and how it ensures job security for educators when they need time away for medical reasons or family emergencies. To shed some light on this often confusing topic, we're joined again today by ATPE Member Legal Services Department Managing Attorney Lance Cain. Welcome back to the podcast.
Thank you, David. Always a pleasure to be here.
In the previous podcast, you had brought up the concept of protected leave. Would you mind expanding on what it means for the leave to be protected?
Yeah, for Texas educators, we consider the FMLA, which stands for the Family and Medical Leave Act. It's a federal law. And then TDL, which is short for temporary disability leave, and that's a state law, to be protected leave. In that sense, both laws provide varying levels of job protections against discipline, like reprimands for excessive absences and terminations for excessive absences. And both have protections when it comes to returning to work. And while there is some overlap between the two, it's probably easier to talk about them each separately. So we can go ahead and start with the FMLA.
Are there any scenarios where an educator might not be protected under FMLA or even TDL?
There are. Both have eligibility requirements. We'll kind of get into the details a little bit more, but there are situations where, for example, the FMLA might not apply, or for reasons that might cover an educator under the FMLA, temporary disability leave might not apply. So yeah, we'll definitely discuss some of those scenarios.
So how does an educator go about requesting FMLA?
All right, so yeah, that's a good place to start. The FMLA request should be made to Human Resources. A lot of educators might start with their campus administration, but HR really is in a better position to maintain confidentiality of that health information that an employee may be required to share. That also applies to TDL, temporary disability leave. So any communications really or medical documentation should be handled through HR. And then what HR does, or Human Resources, what HR does is they'll communicate the necessary information to the campus administration. So the expected length of the absence, things like that. So the campus administration can handle it from a staffing standpoint. But really the specifics of the medical condition should be kept confidential. So HR is better situated to do that.
Are there any eligibility requirements for FMLA?
Yes, there definitely are eligibility requirements. The educator has to have at least been or worked for the employee or for the employer for a year, and also in that previous year, they have to have worked at least 1,250 hours. So that's a couple of the just basic eligibility requirements. There's also a requirement that the employer itself have, I believe it's 50 employees at least. Most Texas school districts are going to have that, but there actually are a few out there and a few charter schools as well that might not meet that sort of threshold. And then there's obviously eligibility requirements for the type of health condition as well.
So what happens if an educator doesn't meet those eligibility requirements, but they still need the time off?
Well, then if they have paid leave with the district, they can apply for it that way. If they don't meet the eligibility requirements for FMLA, then they might still meet the eligibility requirements for temporary disability leave. The requirements are a little bit different for TDL. And so they don't have that same sort of work requirement that they worked for 1,250 hours. The FMLA is a little bit better, but temporary disability leave might be available to employees if they don't meet the FMLA requirements.
And what about documentation? What is required of the employee to file for this?
Yeah, that's a very important requirement because if they fail to provide proper certification, that can actually lead to the employer denying FMLA. The district can require that the employee's FMLA leave be supported by certification of the serious medical condition, and the district may have a specific form that the employee can take to their doctor. So a lot of times that's how it's handled. And also a district can seek clarification of the provided certification. So once the district gets the doctor's note back or the form, then they can seek clarification sort of as it relates to handwriting on the form, with the doctor's handwriting and everything, or understand if they don't understand one of the responses on the form. But the district should really not ask the healthcare provider any additional information beyond that which is required on the certification form. It's also important for the employee to carefully read any medical forms that the district is asking the employee to fill out. I've seen quite a few where the district will ask for sort of a blanket release of the employee's entire medical file, which is not really necessary for a specific FMLA request. So that's going to be something that the employee, they don't want to sort of release or authorize the release of too much medical information. And the employee, may have a good reason that they don't want to have that sort of entire medical file released. A district can request recertification, so if it's like an extended period of leave, but no more often than every 30 days, and only in connection with the absence by the employee. So it's something that the employee can sort of ask for continuing medical documentation of a very extended period. And also the district must allow at least 15 calendar days for the employee to provide the recertification. So there is a time limit there.
You mentioned submitting the medical certification and other documents. Are they strict deadlines when submitting those? Is that something that you need to be aware of?
Yeah, they are fairly strict, and so if the district is, basically requesting the form back from the employee and those timelines are running, the employee should be aware of that. The district should generally work with the employee to resolve any incomplete documentation. But if the employer wants to be strict about it, they can definitely potentially even deny FMLA if the timelines aren't met.
Now, I've heard that a district can ask for a second opinion. Is that true?
Yes, the district can ask for a second opinion if they have a reason to doubt the validity of the medical certification. They can actually ask the employee to go and get a second opinion at the district's expense. So the district, would sort of select a doctor to perform a second opinion, and the district would have to pay for that.
And if you feel that second opinion is not fair or accurate, can you challenge that as an educator?
We don't see it much, but I think the way it works is if you have the first note from the educator and the second note from the district's provided doctor, then a third sort of tiebreaker opinion can come into play. So if the district's sort of designated healthcare provider differs from the employee's healthcare provider's opinion, then it's usually the district, I think, that seeks the third healthcare provider, again, at the district's expense.
And what type of medical conditions qualify for FMLA?
So a serious medical condition is a pretty broad definition. And the employee's own serious medical condition qualifies. Also, because it's the Family and Medical Leave Act, if the employee needs to care for the serious medical condition of a close family member, which is defined as their son, daughter, spouse, or parent. So it's a limited group, but it still is more sort of it broadens the scope of the leave, where other types of leave like temporary disability leave wouldn't cover that. Also, for the birth of a child or care of a newborn child, and for the expectant mother, any condition before birth that qualifies as a serious medical condition. So it could be after the birth for childcare, or if there's a situation where the mother is sort of experiencing her own medical condition, she can take FMLA for that as well. It also covers an employee who adopts or fosters a child. And also, there's some special rules that allow an employee to care for a close family member injured in the line of military duty. And then also in certain qualifying exigencies relating to a close family member's service or deployment.
So how much leave will FMLA provide?
The FMLA itself provides up to 12 weeks of leave during any 12-month period. It's actually extended to 26 weeks if the employer is acting as a military caregiver. So under those circumstances, it's extended an extra 14 weeks. And then there's a special rule which sort of combines or limits the leave if both spouses or a couple works for the same employer. The total leave is sort of a combined 12 weeks if the leave is taken for the birth of a child, or the placement of the child for adoption or foster care, or to care for a parent with a serious health condition. So it's something that in those specific circumstances where both spouses work for the same school district, it can be sort of combined. It's also important to note that the 12 weeks is unpaid. But if the employee has accrued paid leave, like state or local paid leave, they can use that concurrently with the FMLA. So a lot of times the employer may be sort of required to use paid leave if the district has that in their policy. So it's good and bad. Sometimes the employer doesn't want, or the employee doesn't want to use their paid leave, but because of the employee's policy, they're required to use it. But at least they will be getting paid for that time off.
Do you have to use all 12 weeks at once?
No, the FMLA can actually be taken in separate blocks of time for the same underlying reason. They call that intermittent leave. And employees may also be able to take a reduced leave schedule, which reduces an employee's usual number of working hours per work week, or hours in a workday. However, there has to be some type of medical leave for the need. It's still required that the medical need is sort of best accommodated by an intermittent or reduced leave schedule. So if that fits the medical leave pursuant to the doctor's note, then those situations might apply. Now, there is an exception for cases that involve the birth or adoption of a healthy child. The district has to basically agree to intermittent leave or a reduced leave schedule. And then the FMLA regulations allow a district to temporarily transfer an employee to an alternative position in situations if the employee is requesting intermittent or reduced leave schedule that is sort of foreseeable based on a planned medical treatment. And then that new position better accommodates the recurring leave. So there is some ability for a district to temporarily transfer an employee. And then there's some special rules that apply to instructional employees, and those are ones that are defined as an educator whose primary function is to teach and instruct students.
Can you give us a little more information about the special rules that you're talking about for instructional employees?
Yeah. So first, in instructional employees, they're required to give at least 30 days notice to the district if they plan to take leave intermittently or on that reduced leave schedule. If they don't provide that required 30-day notice, then that gives the district the right to require the employee to take the leave as one block of time for the entire duration. So that particular time limit, that 30-day notice, is important if the employee prefers to take intermittent leave, because if they don't meet that, then the district can say you need to take all 12 weeks at once. And alternatively, the district can temporarily transfer the employee or require the employee to delay the treatment until the proper notice is provided. So that can sometimes interfere with, a doctor's schedule or a scheduled surgery that might, have been scheduled for 4 months. So the employee really needs to keep in mind those deadlines, because the 30-day notice can have some pretty dramatic effects on the employee if they don't meet it. Also, instructional employees are restricted by what they call the 20% rule. So if the intermittent leave or reduced leave schedule is foreseeable and would require the employee to miss more than 20% of the working days, basically 1 day a week, then the district has the same options as with the notice requirement. So they can require the employee to take leave in a block or temporarily transfer the employee. So that's something as well, that the intermittent leave, if it's more than 1 day per week, then there can be some difficulties there. One last special rule allows a district to require an employee whose leave is taken at the end of a semester to remain on leave throughout the end of the whole semester. So if someone is sort of, requesting leave towards, April or maybe early May, the district can say, we're going to require you to stay on leave for the rest of the time. However, once the employee is medically cleared to return and ready to work, the additional leave that's required by the district is not subtracted from the employee's FMLA entitlement. So it's sort of a benefit to the employee. Even if the district says, it's because it's the end of the semester, we're not going to bring you back at this time for whatever reason. Once the employee receives that notice from the district, the employee's FMLA leave is not counted, or that additional leave is not counted against their FMLA entitlement.
So how is intermittent leave calculated? How do the school districts track those leave hours, especially in a setting where your schedule can vary?
So only the amount of leave that's actually taken can be counted towards the employee's leave entitlement. A district has to account for intermittent or reduced leave schedule using an increment no greater than the shortest period of time that the district uses to account for other forms of leave, provided that time is not greater than 1 hour. So if an employee needs 3 hours in 1 day, they should only count those 3 hours off of the employee's FMLA entitlement of the 12 weeks. However, since the FMLA is unpaid, we kind of run into a situation where sometimes if the employee is wanting to use paid leave concurrently, the district's paid leave policy may conflict with that rule a little bit, because some districts use a sort of a half day for paid leave increments. So as a result, an employee might need just 2 hours of FMLA for an appointment, and they would only have 2 hours of FMLA deducted. But if they want to be paid that day, they might have to be required to use a full half day or 4 hours of paid leave if they want to get paid. So there's a little bit of conflict there, and it is confusing. A lot of members will call us and be confused about sort of that sort of distinction there. But that is one situation where an employer can require sort of extra time for the paid leave component. Still, the FMLA the subtracted amount of FMLA is going to be accurate. But so in those situations, I'd usually recommend just maybe taking the full half day for the employee so they can get full use of that.
And what other benefits does FMLA provide?
One of the biggest benefits, in my opinion, is the job reinstatement. So upon return from FMLA leave, an employee is entitled to be returned to the same position that they held when the leave began, or to a very equivalent position. An employee is entitled to reinstatement even if the employee has been replaced while they were out, or if his or her position has been restructured to accommodate the employee's absence. So we get into this a lot where, sort of what is the definition of an equivalent position? And, something comes from, maybe a teacher who's teaching 5th grade, they go out on FMLA, and then when they come back, they're returned to 2nd grade. The FMLA actually doesn't get that specific. I mean, it does have to be an equivalent position, but to define that, you look at certain factors like benefits and pay, other terms and conditions of employment. And so in situations like, fifth grade to second grade, when the pay, benefits, length of the workday, that type of thing are the same, a return to a different grade level might be allowed by law, even if it's not the teacher's preference. And then during the FMLA leave, another benefit is that the district has to maintain the employee's coverage under any group health plan on the same conditions as they would have been providing if the employee had been working. So if an employee covers 100% of an employee's sort of healthcare premiums while they're working, they have to continue to cover the employee on that same level while they're on FMLA. If the employee pays a portion of healthcare premiums, the employee must continue to pay the same portion. And so, some districts, now that insurance is getting more expensive, they might only be covering half or something like that. The employee does have to continue to pay that. If they don't, then the district can terminate the coverage. So as long as they have to provide 15 days notice, but it's important for the employee to keep paying whatever portion they pay. And usually that's going to come out of their paycheck. And also, if the employee fails to return at the end of the FMLA leave, this is one thing where a district can sort of kind of get that money back if the employee is taking FMLA leave, and then they just end up resigning from the district or don't return. So in that situation, an employee can actually deduct it from a final paycheck, or if there's no paid leave available or the employee wasn't getting paid, they can send a bill to the employee. So, and that's just for the health insurance premiums. So a district may not recover its share of health insurance premiums for any period of FMLA leave covered by the employee's paid leave. So the employee is getting paid. That rule is a little bit different. But we see a lot of times where the leave is extended over, multiple weeks. A lot of times they will run out of pay.
Are there protections in place for educators who might face retaliation for taking FMLA leave?
Yes, that's another important benefit because an employee does have those protections against discrimination and against an employer interfering with their rights under the FMLA. So if the employee feels like they're being discouraged from taking FMLA or retaliated against while they're on FMLA or once they return, then they can file a complaint with the U.S. Department of Labor.
What does an employee need to do when it's time to return to work from FMLA?
Well, for one thing, they should take a look at whatever their district requires, because a district can require an employee on FMLA to basically report periodically on their status and intent to return. So if that's part of the employer's requirement, the employee needs to make sure to keep up with that. And then a district can also require the employee to obtain and then present to certification from their healthcare provider that the employee is able to resume work and can perform the essential functions of their job.
What if they need to request accommodations when they return?
Yeah, that can sometimes be a situation as well, where the employee might need some kind of workplace accommodations. That would be through a different federal law, the Americans with Disabilities Act, but that would be something that that an employee could request accommodations to help them perform the essential functions of their job.
Before moving on to TDL, are there any other pieces of relevant information relating to FMLA?
Just a reminder that it's a strong right, and it gives a substantial amount of leave. 12 weeks is a pretty good chunk of time, without the concern that they're going to be disciplined or terminated for excessive absences, but also that it is unpaid. So the employer needs to be prepared for the financial impact if they don't have a lot of paid leave days saved up.
And so the other type of protected leave is TDL. What are some similarities to FMLA?
Well, so first, they both provide that protection against discipline for the absences themselves. So that's a good right. An employee who's on FMLA or TDL shouldn't be written up or terminated for excessive absences. A lot of times, educators will call us sort of too late after they've already been out 10 days or something like that, and will say, well, my FMLA, or sorry, my leave was to care for my son or something like that. And then the district will give them a reprimand, or some districts are pretty strict about absence limits, might even propose termination or non-renewal of their contract. So it is a good idea to get on that type of protected leave if you're eligible for it, because once an employee is disciplined for missing days, a lot of times it can be difficult to go back and sort of retroactively apply the protected leave to that. Another similarity with FMLA is that temporary disability leave also gives the employee a reinstatement right. So once they return from work, the FMLAs is much better, I have to be honest. But when you return from TDL, an employee should be given an assignment at a school where they formerly taught. And it's also sort of subject to the availability of an appropriate teaching position. So it's not nearly as strong as the sort of same equivalent position language from the FMLA, but it does give the employee some rights. And then when the notice requirements aren't met, the employee can return from FMLA as soon as their doctor clears them. I'm sorry, when the notice requirements are met, the employee can return from FMLA. But under the TDL, the district has a little bit more flexibility to keep the employee out and on leave until the beginning of the next term, which is understood to mean the semester. So even if an employee's doctor releases them to return to work from the temporary disability leave in March, the district can actually hold them out for the rest of the spring semester. A final similarity is that both require medical documentation of the inability to work, and like the FMLA, TDL requires a physician certification to return to work and does have a notice requirement. The notice requirement for TDL is that the employee must notify the superintendent of their return to active duty no later than 30 days before the expected date of return. So that's something that an employee needs to sort of keep track of that on their calendar if they're going to be out on TDL. If they know when their return date is, make sure to keep track of that 30-day return.
So talk to us about the differences between TDL and FMLA.
One of the major differences is the eligibility. So in most cases, FMLA is eligible to any employee in their first year if they've worked 1,250 hours. After their first year, if they've worked 1,250 hours. And TDL is only applicable to full-time educators. So that's an educator if it's an employee whose position requires a certificate. So like a teacher, administrator, thumb aides. So basically, TDL is eligible to employees where their position requires a certificate, but it is eligible in the first year. So that's a little bit better and that's one of the few situations where TDL is better than the FMLA. Another difference is that TDL is only available for the employee's medical condition. So unlike the FMLA, you can't use TDL to care for a close family member. A big one is that TDL cannot be taken intermittently. I guess a district could allow it informally, but it's not required by law. And then sort of from a financial standpoint, temporary disability leave does not require the district to continue with those health insurance premiums. So they can charge the employee the full cost. The final main difference is the length. As we discussed, FMLA is 12 weeks. TDL is 180 calendar days, so it is actually a little bit longer. In most cases, the way it works is that they run concurrently. So when an employee will need some type of extended leave and requests FMLA, the district actually will start running the TDL simultaneously. Then after the FMLA's 12 weeks are up, the FMLA is over, and then the employee is just on TDL for approximately 3 more months.
Well, what happens when you run out of FMLA and TDL? Can you be fired?
Typically, yes. An employee can be terminated after exhausting all of their protected leave, like FMLA and TDL. even if there's a contract, excessive absences can be considered a good cause to terminate a contract.
What kind of accommodations or other protections are available when you've exhausted your leave options, but you still need to be off work?
So one possible exception is if the employee has a disability that qualifies them for accommodations under the Americans with Disabilities Act. There's some guidance in the ADA that allows an employee to request additional unpaid leave that can be considered a reasonable accommodation if there's no alternative accommodation. So if the employee can't sort of return, on a limited basis or part-time, and if the additional unpaid leave doesn't pose an undue hardship on the school district. So there's still that analysis. All ADA requests are determined on a case-by-case basis, so can't get into too many specifics now. But it is helpful if the doctor can certify that a return date is sort of imminent, not too far off in advance, maybe a month or two. So in those situations where an employee has a very serious medical condition, they've gone through their FMLA, they've gone through the TDL, 180 days, but their doctor is saying they might be able to return in another month or two, that's a good opportunity for the employee to request that additional unpaid leave as an accommodation. And the employee would have to consider it and work through the ADA analysis just like they would any other accommodation request.
Is there anything else educators need to know about this topic?
No, just that there are some important rights that are combined with some important timelines and things that the employee is required to provide. So make sure that the employee does their part as well, to work with the district and HR to try to get that information to the district in a timely manner. And then they can, contact member legal services if they have specific questions about how it's working or denials or things like that, and we can guide them through that process.
Well, Lance, thank you so much for being here today.
You're very welcome. Hope this information is very helpful to our members.
As always, if you have any questions or feedback, you can send those to comm@atpe.org. That's COMM@atpe.org. And we encourage you to subscribe to the podcast as well as leave us a review. Thanks again for being here, and we'll see you next time on the ATPE podcast.
Thanks for listening to the ATPE podcast. For more information about becoming part of Texas's largest community of educators, please visit atpe.org.